Hello, everyone. Welcome. We are live with a new episode of Level Up Law. Every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. And today we are excited to bring you episode 2 in a series on federally subsidized housing with our housing law unit head, Matthew Billingsley, who you see on your screen right now. He'll be talking about how eviction works with federally subsidized housing. But before we go to Matt, who is an attorney in our Charleston office and head of our housing law unit, we just want to remind everyone that this is not legal advice. It's just general information for the public, but it is important information, so we're glad to have you with us live or on the replay. And if you need the help of a lawyer on this or some other topic, do call our intake line here at South Carolina Legal Services, or you can also apply online 24/7. That information will be provided at the end of today's presentation. Also, as a reminder, all of our episodes are posted by our producer, Kenneth Elliott, who is here with me today in the background, making sure all the bells and whistles are working back there. And I'm Susan Ingalls, Senior Staff Attorney here at South Carolina Legal Services, and I'll be turning things over to Matt in just a moment. But first, I want you to look at that QR code on your screen. If you want to sign up for our newsletter here at Legal Services, just scan that QR code, and it will take you to a form. Oh, there you go. That'll take you to a form that will enable you to give your information so you can sign up for the newsletter. And then I think at the end of today's presentation, we have another QR code. We'll show you this one again, but we also will have another QR code that you can scan. If you have an idea about a legal topic that you would like us to cover here on Level Up Law, you can send that in to us. We always appreciate that. Also for today, Matt can answer general questions if there is time available at the conclusion of his presentation. So just put your questions right there in the question box on your screen, and that should take care of it. So I'm going to let Matt take it away for an overview of eviction when you are in federally subsidized housing. Thanks, Matt. Take it away.
All right. Thanks, Susie. I'm going to go over a little more. I think last week we went over what subsidized housing essentially was, and today is really just about reasons for eviction and that kind of process. So going over in public housing and how that relates with evictions. Generally, just as a recap from last week, public housing is where a housing authority owns and manages the housing complex and is formed under public housing laws. There are other subsidies, and you know, we might hit on that a little bit. They all have a very similar theme with reasons that they can evict someone or terminate a lease. Okay, so here are a list of some of those reasons. There's always a few more that maybe aren't listed, but just as a regular landlord-tenant matters, private landlord-tenant matters, rent is always an issue. Obviously, in subsidized housing, you're paying a reduced rent, a lower amount based on your income, but you still have to pay that in order to remain in the housing. That is still a way they can file for an eviction. Other issues that come up that I see quite often, the failure to report income comes up a lot. One thing you'll see in subsidized housing, it's true in public housing, it's true if it's a private company that's running a project-based Section 8 voucher program or something like that, where you have to do a recertification, usually each year. And in addition to that, if your income changes more than $200, you need to notify the landlord so that they can do what's called an interim recertification. So if you fail to do that, if you don't report that income, that can become a problem. It can cause you to owe a retroactive amount of rent. If they think it was intentional to not report the income, then that could be the grounds for a lease termination as well. So also along those same lines, reporting who's living in the house. You can't have unauthorized people live in the house who aren't listed on the lease. You could always add someone to the lease or ask to add someone to the lease or to the household. You just really need to watch out for letting somebody move in who's not supposed to be there. They can also have an issue if you fail to accept the new lease. The big things, though, that really I see a lot are drug-related criminal activity and criminal activity that threatens the health, safety, and right to peaceful enjoyment. That is a language you'll hear a lot with these, and quite often the things that I see don't always involve the tenant themselves. It could be a member of the household. It could even be a guest who does something while they're on the property that can cause a lot of these problems. Abuse of alcohol, usually these things or some of these things like abuse of alcohol and these criminal activities have to threaten health and safety or something like that. So there's a little more to it, but they do have standards, and they do sometimes review people for inspections on cleanliness and those kind of things. Those are probably one pet peeve of mine dealing with those, because there's a lot of times it's very subjective between whoever is doing the inspection on what it means to really violate that and not. Also, they can also charge you for other damages or things that are caused by you or a household member or your negligence. That could be considered a lease violation if you're not able to repay that or try to repay it, I think, in a reasonable way. There's a little, all these have a little more further details that can be gone into with each one. It's usually just not as simple, though, as, well, you violated something, you can automatically be evicted or whatever. The trash violations, things like that, anything that's a lease violation, and also can be lease violations that build up. Repeated minor violations, which would be something that you violate that's maybe a smaller thing, but then you keep violating the same thing multiple times. They could use that to try to do an eviction. But generally with these, what it illustrates is the idea that in order to be evicted from subsidized housing, usually you have to, the landlord has to have a good reason, what they call a good cause. They can't just evict you because the lease term has ended like they can in private landlord tenant. The only one where that comes up where they can do that is in a housing choice voucher, where you're leased with the landlord, you're treated like a private tenant, even though you have a voucher that's paying for part of your rent. Okay. What does the housing authority have to do in this situation? And this then applies to if it's a property complex that is subsidized under the project-based state program, then they have very similar requirements as to this. They have to get a written notice. That is a written notice prior to them filing a case for eviction. So it's not written notice just to go and file it in court. There are some things in the law that says the landlord in that situation, or the housing authority, does not have to give written notice for a couple of, there's a couple of ones that they don't have to on that. Usually it's something severe that could be like violent criminal activity or criminal activity that's drug related, or I think, some things like that. They may not have to notify you ahead of time on some of those, or they might have to notify you, but they also don't have to necessarily give you a grievance on some of those things because of the nature of them. But the notice will tell you, how many days you have to your lease ends. A lot of times for violations, it can be a short amount of time for severe violations or things like violent criminal activity or drug-related criminal activity. However, in my experience, I've seen a lot of housing authorities and project-based landlords will usually give around 30 days in the letter, and they just kind of make that their standard practice. So oftentimes you'll see that. So pay attention to the letter when you get it. What does it say is very important, and when it tells you they're saying your lease is going to end, is very important. What it's supposed to say, have in there, is the reason for the termination. So that's going to be why they're ending your lease and asking you to move or saying they're going to file an eviction if you do not move. It's got to tell you have the right to respond. You have the right to defend it in court, essentially, if you need to. You also have the right to look at any documents or be provided any documents that the housing authority will use. The regulation that is really important, and if you were seen last week's and all we talked about it, is 24 CFR 966.4. You know, if you put that in Google, you Google that, you pull it up, that will really give you just about all the information you really need to know relating to public housing and your rights and that process with them. So that's where all this comes from. They also have to tell you have a right to a grievance hearing with the housing authority. And if you don't have a right to a grievance hearing, and that's what I mentioned before, that's with certain types of violations. There could be certain types of maybe violent criminal activity or something like that. It's in the regulation, but it will have to say, you know, you're not entitled to a grievance hearing for this reason of termination, or they'll say that you do have a right to the grievance hearing. So usually for when you get the notice, if you want a grievance hearing, an informal like meeting, grievance hearing, usually that has a time frame in the letter. A lot of times that's generally 10 days in order to do that. You can go through that process. I've been through that process several times with housing authorities where that will happen before they decide to file in court. And essentially they'll have a kind of the similar way they do for a housing choice voucher. They'll have a little informal hearing for the hearing officer that is to determine if they're doing things right or if they think that they're allowed to move forward to the eviction. So I've had some that have moved forward, and I've had some that the housing authority, the administrative process has stopped and said, no, we can't move forward. All right, so what happens at that hearing? And sometimes with these, they may first do this more informal, just meeting discussion. They'll explain the reason you're being terminated. Obviously, you can represent yourself. You can provide your information on what your side of things are. You can get an attorney. You can contact South Carolina Legal Services to seek help with that. Usually, that's the best thing to do. Once they make their decision from that meeting, they have to tell you what that decision is, give you the details of that decision. If you're not satisfied with it, you can ask for that full hearing with a hearing officer. Usually that tells you a time frame in that. One thing that I would say is with those kind of discussions and with having that kind of meeting with the housing authority or the property manager for the housing authority, one thing you want to be careful of is just be careful of what you say. Anything that you say at these, can be used against you later when you're in court or an eviction, because they can testify that if you said, one thing or what you told them at that meeting. So I usually advise people just be careful of what you're saying, and be aware of that when you're having that meeting or any hearing with a hearing officer. So when you have a hearing with a hearing officer, you can obviously see the documents as we talked about. If they don't give you a document or provide you a document when you requested it, then they can't use it against you in the hearing or in the court. So that's an important thing to remember. If they don't respond, they don't give you that right, then they can't really use it. So again, keep in mind the right to an attorney contacting us at South Carolina Legal Services. You can also get a private attorney or try to get someone to assist you with that. And it's similar in a way, these kind of hearings, in my experience with the hearing officer, is kind of similar to an eviction with a magistrate. You have a hearing officer. The hearing officer may or may not be an attorney. Some housing authorities I've seen do it very different. It has to be someone who's not involved with that particular department. It could be an employee of another department of the housing authority. I've seen sometimes housing authorities where they will have community volunteers. I've seen some where they will get either law school students or the other attorneys that they will kind of contract out to be the hearing officers. So it is very similar in that way. It's a more informal process. You know, a lot of times they will record it. Sometimes they don't. If you want it recorded and they're not recording it, you may want to bring in a tape recorder or discuss that with them ahead of time if you want to have a record of kind of what's said. But keep in mind, and this is the important part, even if you go through that process, that grievance process that you raise through the Housing Authority for public housing, you don't get that same process if it's project-based Section 8. But they have to actually go to court to evict you. So that process with that hearing officer, if the hearing officer sends a letter or determination and says, well, I think the Housing Authority's right and I think they can do that, all that means is now they're going to go to court. And the court doesn't just say, well, the hearing officer said. You know, the court is a new thing. So it's almost like that hearing with the hearing officer and the Housing Authority is in a way, it can be a way to stop it from getting to court. It can also then be a way almost as a practice to see what they're going to say to be able to prepare for it. You may be able to be better prepared by the time it goes to court if that's what happens. But they will have to ask the court to evict you, and that will go in the same way that any other landlord-tenant action does. With a filing in the magistrate court, the magistrate court will serve you. You have 10 days to request a hearing with the magistrate court, and the court will then schedule a hearing when you request it, and then you can present your case and your defense, and the Housing Authority can present theirs as well. Okay. You have to be personally served with it. The rules are that they will personally serve you with it or try to personally serve you with it. If you're not there, they'll post it on the door. They'll come back. I think it's like maybe at least 24, maybe 48 hours later at a different time of day, separated by a certain amount of hours, they will go and try to serve you again. If you're not there, they'll post it on the door a second time, and then they'll get $5 from the landlord and they will mail it to you. Service will count. Once they mail it, service will count, I believe, after 10 days. And so that means 10 days from the mailing date, your count is being served, and then you have that 10 days from there to request a hearing. Keep in mind that if it is posted on the door and you call into the court, that is you acknowledging that you've received it, and that counts as service on that day you're calling to the court. Okay, so basically just a little bit about South Carolina Legal Services. You know, what I can do here, let's see. And this is going to be I think a little more important, is when you get served, because this kind of applies whether you're in subsidized housing or not in subsidized housing. It's the same either way for this part of it. We talked about how what happens when you get served. You can call South Carolina Legal Services, you can ask for assistance, but keep in mind, if we don't immediately respond to you or there's a deadline the next day, just because you've called us, that deadline doesn't stop. So you need to make sure you're meeting those deadlines for requesting that court hearing if you're not sure you're within that 10 days. As we talked about 10 days, if you don't, they're going to assume that you are acknowledging that whatever they're saying is accurate, and that admit it's kind of what they would call default, and essentially admitting that they can evict you. If you contact the court, then they should schedule a hearing. They would schedule a hearing in front of a judge. Be aware that there's a lot of magistrate courts out there. There are a lot. In every county, there are a lot. And there's various magistrates even within the county. And some courts, even within might be in the same county, might still do things a slight bit different. I've heard some magistrate courts will require people to come in person and request the hearing. Some will ask them to fill out a little short answer form or something like that. So just be aware and try to be aware with what the court is requiring of you to get the hearing. I'm not saying whether it's right to make people come in person or not or whatnot, but it's a lot easier to get that hearing as best you can than trying to figure it out down the road after there's been a writ of ejectment or something, and trying to unwind things and pull things back. So it's a really important thing to not miss that. And a lot of people sometimes will miss that. Don't think just because you've talked to the landlord or the property manager that they're just going to tell the court or something like that. That doesn't count, just talking to the property manager. You've got to request that hearing from the court, okay? If you want a jury trial, you have to do that in writing, and you have to do that at least 5 business days before the date of the trial. That should mean that the court should be scheduling you a hearing at least more than 5 business days from when you request it. That may not always happen. If they schedule you one too fast or something like that and you want a jury trial, I would say put it in writing, tell them you want a jury trial, and move forward with it from there. All right, so here are a few things that if after the eviction itself, if a judge rules against you and they evict you, you have a couple of options. You have 5 days to ask for a new hearing, and that's usually relating to some specified reason. You know, you could ask for a new hearing because, you know, maybe you discovered some other piece of evidence or something that you didn't have on the day of the hearing, or there might be something else that comes to light right after that. You could also, within that kind of same time frame, ask almost, you know, in a way similar to reconsideration, what they call it, kind of saying, well, Judge, I think you should reconsider because I think you got something wrong or got something with the law wrong. While technically you have 30 days to appeal a judge's decision in an eviction, not really. And the reason I say not really is what's right below that. You could have to leave the home within 48 hours. The way a writ of ejectment works, and the problem with a writ of ejectment is it's not really a clear time frame practically. Landlords will ask for the writ of ejectment. They'll pay their $10 to the court. The court then has to proceed with executing that writ of ejectment and putting that writ of ejectment, serving that on you, and then enforcing it. Once they serve a writ of ejectment and they're going to enforce it, they have to come back at least 24 hours later. In my experience, a lot of magistrates, the constable who does that and then comes back, or they come back with the sheriff's deputy or someone, they usually have some kind of a process that they do. Different courts will have a slightly different process. And it's good to follow up with them to know what their process is so you are better aware of what your actual time frame is. If you want to appeal the judge's decision and stay living where, you know, in your residence while that appeal is going forward, then you better do that appeal before they actually put you out with that writ of ejectment. It doesn't matter if they've served you with it when you do your appeal. You just, in order to stay there, you're going to have to still be there. So it says 30 days, but if the constable is bringing a sheriff's deputy to put you out, you know, on the 15th of the month, and technically you should still have to the third, you should have another 10 or 15 days to do your appeal. Well, if they put you out, it's good. It's not going to seem like there's a lot of point to your appeal at that point. So while you do have 30 days, keep in mind, if you want to stay and you want to appeal, you better appeal it to the Court of Common Pleas prior to them actually putting you out of the home. And that is something that we always have to be aware of. I've had many cases where something happens and that 30 days really shrinks to just a few days or 5 days or something like that before the person's going to get put out if I want to stop it. Okay. Some courts, and I've seen some courts that will have kind of similar to how sometimes brochures are set up or things, information is set up. I've seen them sometimes that will have the forms or some appeal forms or things like that. There's a notice of appeal form to do an appeal. If the court doesn't have it, you can find it with the court's website. sccourts.org is our court's website. They do have a link for documents, and you can search documents there, magistrate forms or common pleas forms, but it would be called a notice of civil appeal. Okay. You still have to pay rent during that time. The other thing that is important is you have to file with it what's called an undertaking. And all the undertaking really has to say is, I will continue to pay rent during my appeal when it comes due, whatever that rent is. If you're paying your $100, public housing, $100. If you're not having to pay rent because you're a negative renter and you get a utility check, that's what it would still be. But you have to basically put that undertaking or statement that you're going to do that. Okay. Some courts will then have a hearing on that to set the amount of rent and make sure it's all understood by the parties. At that point, then you would not be able to be evicted until the appeal is heard, unless you don't pay the rent. If you don't pay the rent while the appeal is going on, and it's the same rules, time frames, usually on the 1st and late after the 5th. If you don't appeal it, they will notify the court, and the court will lift the stay at minimum, which all that means is they will then say, okay, they can proceed to put you out. Your appeal might still go forward, depending, but you won't be able to stay there if you don't continue to pay rent during that time. So keep that in mind. It's important to know. Okay. All right. So that is obviously a fairly short, quick overview of what some of your rights are with public housing and evictions. We could spend lots and lots of time and go further into detail on certain types of evictions and reasons for it, as I mentioned before, things like an unauthorized occupant, or things like violent criminal activity, that usually it's criminal activity, the magic words, or that threatens the health, safety, or right to peaceful enjoyment of the other residents or those in the immediate vicinity. Also drug-related criminal activity. These are things that come up quite often, not just for, like I said, the tenant, but I have a lot of cases where something comes up and it's a guest. It's someone who was there, and something happens, and now they're stuck with the consequences of it. So we could go into those at later times, I think, to really go into the nuances of all those. But today's session, the point of it is to get an understanding that you have rights. You have rights to challenge it with the housing authority of what they're telling you. You have rights in court to defend yourself, and that unlike private landlord-tenant in your everyday landlord-tenant cases, housing authority or project-based Section 8 landlord cannot just simply evict you at the end of your lease term. They can't say, I just don't like Mr. Smith over here, so I'm going to end his lease and I'll be done with him. We're not going to renew it, and you just have to move. The letter might say something like, we're not going to renew your lease, but it has to be, we're not going to renew your lease because you've done one of these violations, you've had one of these problems, or something along those lines, which usually means, and to be prepared for it, is finding yourself in court, unless it's something like rent, which is a little more straightforward to deal with. You're usually in these cases going to be dealing with some real contested issues, some really contested matters. It could require and will require a good understanding of the law. It will require evidence, being able to bring any evidence or witnesses that you have, because a lot of these cases, a lot of these evictions, they're having to prove that you've done something really wrong. You've really violated the lease, done something wrong about that. Certain violations, and to keep in mind, there are still state protections. So while it's a federal requirements and federal rules, the state laws, the state protections still apply too, because the federal laws kind of say, in these evictions and everything, these housing authorities and project-based Section 8 landlords have to follow state and federal laws to try to give you the most protection, is what the purpose of that is. And there are some state rules that require an opportunity to cure. So that is one thing to keep in mind too. Another thing to keep in mind, I mentioned this before last week, if you were there, that housing authorities, especially for public housing units, they have what's called an ACOP, and it is a policy manual that sets out what their policies are relating to public housing. Those things can be really helpful. They should give you access to review it or look at it. Some of them will have them online, and they are really, really helpful to be able to look up and go to some of these issues or some of these claims that a housing authority is making, and to be able to see, well, what's the housing authority's policy on that? What is the regulation they talk about? What's the policy? It's really an easier way to go and find that information, because under the regulations, especially the 24.966.4, that's from the Code of Federal Regulations, it does require them to use some discretion in how they're going to evict people. What that means is to look at the household's violation, what's going on with them, how it'll affect everybody, and they'll have a list of that in there where they're supposed to really consider whether or not they should evict this family, instead of just can they. Sometimes before you'd have problems, housing authorities saying, well, we can evict the person, so let's do it. What they're supposed to do is say, okay, can we evict this person? Do they violate or whatnot? And then should we? What's their situation? Let's review these certain issues. They'll look at it for like a household, how it affects all the household members. Is there an alternative to eviction? One common thing that I would look for is if there's one offending household member and it's clear that person can't stay, maybe finding alternate housing arrangements for that one family member. It could also be, in some cases, that it was a guest or something like that. And sometimes they might agree that that guest will not be invited back, or that guest will not be a guest anymore at the property due to that violation. So there are ways to try to work something out. And the reason I tell you that too is to don't be afraid. Be aware if you're talking to the housing authority that what you say, they can testify to that at some point. But just be aware and don't be afraid to talk to the housing authority, your landlord, the property manager, about trying to figure out, is there something you can do if you're accused of something, or if a guest is accused of something, to try to work things out or try to avoid that whole process. And it's important, to remember, I have a lot of tenants, whether it's public housing, not public housing, where they don't feel like they can talk to their landlord, and there are some things that probably could have been avoided if they were just able to have that conversation. So keep that in mind. That's also something to bring up at the informal meeting or hearing, if you have a grievance hearing, is to say, well, can't we do this or that if this person was the offending party, they're a guest or whatnot. And that's why it's important to really look at all the information and to see what their policy is. I'm not surprised, and I have had it where a housing authority was not aware of what their own policy was relating to a particular part, or they might have a different understanding of that policy. So don't be afraid to talk about it with the property manager and see if you can get something resolved before you go down that process. It's not a fun process to go down. There's a lot of uncertainty, and if you lose your public housing, then that can be a problem to get back on the public housing, and it can take you some years before you're allowed to get back on public housing or any other subsidized housing. So that's something to keep in mind as well. All right.
Those are really important takeaways, I think, for today. And I did want to mention a couple of things, Matt, before you conclude. We do have a couple of questions, and also wanted to make sure that we alert our audience that we do have a previous Level Up Law episode about filing an appeal if an eviction doesn't go your way and you're going to be evicted. And I believe that has with it attached our sort of guide to appealing an eviction decision. So I would definitely refer our listeners, both live here today and on the replay, to check that out. But if you don't mind, I wanted to catch before you conclude these two questions.
Okay.
Okay, and while you're answering the questions, if you're able to, I will let our audience know to scan this QR code if you've got a episode idea for us, we'd love to hear it. We always want to make sure that we're giving the audience what they want or need when it comes to some legal information. So here's first question. Is there a certain time frame that plays a factor when a house is dirty? In other words, does it have to be dirty for more than 30 days or something like that, if that's sort of what the issue is?
I mean, generally with the cleanliness part, what I see is they'll do a, and it changed a little bit. I mean, obviously with COVID the last few years, places may have modified that, but they would come and do like an inspection. It almost reminds me of, like your parents coming into your room or something to see if you've cleaned your room, or it's a little bit odd to me, but a lot of times they'll have a checklist and check what parts of the checklist, I guess what they're supposed to check, what parts are, acceptable, what parts are not acceptable, and they'll make some notes or whatever at the bottom. A lot of times what I see is they'll make some notes if you essentially fail the inspection and say, you've failed the housekeeping inspection and we're going to come back. And usually they'll come back, they'll give you a time frame and tell you, we're going to come back in say 2 weeks or 3 weeks or something like that. There's not an exact time frame on it, but in my experience, a lot of times when somebody's going to court over it, I'll see multiple inspections that were like, okay, we're going to do another inspection at least, maybe in 30 days. And they a lot of times give people several chances at it. The problem I see is that I've seen some people that said, you need to wipe the walls or something like that, and that might fail an inspection. And I've always had trouble when I've had cases getting the landlord or the housing authority to kind of explain to me what makes a failed inspection. How many checks on unacceptable or whatever. Could you have everything clean and then they say, well, we don't think your walls are clean enough, or something like that, or your stove is not clean enough, and one thing makes you fail it? I'm not really sure. It is definitely, I think, a frustrating part for people because of that. So you may have wonderful property managers who go through and are reasonable about it. You might have some that just have a different thought on how it should be. I haven't really gone back to really check the regulations to see if there is a specific time to come back or whatnot. But generally, under state law, you're going to have at least 14 days to cure something like that. So usually, I just see like anywhere from a 15-day to usually closer to a 30-day reinspection to give you a chance to fix what they've said is not up to par.
Okay. One other question we have from one of our viewers, and that is, are there different criteria or considerations, I guess, for elderly or disabled tenants?
Well, not exactly. Sorry, when we're talking about the time frames and duration of all these things, the rules of the court or the rules in the regular federal regulations, or time frames that you might find in state law, they're all going to be the same. There's not a separate set of rules. However, if you are disabled, you can ask for a reasonable accommodation that could include changing some of those time frames. One example might be your rent's due on the 1st and late after the 5th, but for some reason the disability check comes on the 6th or the 7th every month. You might get a reasonable accommodation that extends that time for you, or it may be that you ask for an extended period of time due to a disability or something like that in order to move or something along those lines. You could ask for that, but there's not really a different set of rules. There are some housing and subsidized housing that is set up for elderly specifically. I'm not sure if they have any different rules on paying rent or whatnot, but I do find that some complexes and some places will still give you additional time to pay rent, or they might make it, instead of late after the 5th, they might give you till the 10th or something like that. But I think the best thing to keep in mind with any of these timeframes is for disabilities, you'd have to ask for a different time frame as a reasonable accommodation.
Okay. Yeah, it seems that certainly seems like there maybe not necessarily different rules overall, but certainly some sense of reasonableness or common sense when it comes to someone who's elderly or disabled as to their
Right.
ability to meet the
Right.
rules they have to meet. So that's good to know. All right, well, that was all of the questions. And I want to, at this time, thank you very much, Matt Billingsley, Housing Law Unit Head at South Carolina Legal Services, down there in our Charleston office, where it's a little bit rainy today, as I understand it, but hopefully that won't keep you from helping your clients the rest of the day and this week. We really do appreciate you taking the time out, both last week and this week, to help us out by providing some information about federally subsidized housing, and in particular today, how that works with eviction from that housing. So thanks for a terrific presentation, Matt. And I do want to also thank our audience. We really do appreciate your loyalty to us. And if you're an audience in the YouTube replay, appreciate y'all too. And if you are on the YouTube replay, be sure, if you feel so inclined, to give this presentation a thumbs up. We always appreciate that. But also, if you know it could be helpful to someone else, do share it out with people you know that may be in need. And while you're there, if you're not subscribed to our YouTube channel, definitely do that. We're always trying to increase how many people are getting this good information out there on our YouTube channel. So definitely subscribe if you're not already subscribed, and sign up for the notification so you'll always know when we post a new video of Level Up Law episodes, which we will do with this one and with future ones. Now, you scan this QR code, hopefully, so you can give us a thought if you have one. And then if there's another slide maybe with all of our information about our social media and our other resources with our website. Yeah, there we go. And again, the QR code there is to sign up for our newsletter. So definitely, if you haven't done that already, go right ahead and do that. And be sure and connect to our social media. We get all kinds of important information out on those social media posts, and we also advertise all of our Level Up Law episodes there. So definitely like, subscribe, follow, and all that jazz. The other thing I do want to mention is on our website that you see here, lawhelp.org and fclegal.org, we have a wealth of resources, not just videos, but other things like brochures, toolkits, online classrooms, any number of things that may help you in your quest to figure out what to do about your legal problem. And of course, again, you can call our intake service, see if you're eligible, see if we can help you with the legal matter that you have. We have great intake specialists. They're always there Monday through Thursday, 9 to 6. But if you can't make it then, or just can't get through, check it out online. You can do an online application and give us all your information that way. Sometimes that's a lot easier with people's work schedules and things. So we do want as many people as possible to get all the important information that we have, both here on Level Up Law and on all the other resources that we have. So that really concludes today's webinar. I do want to encourage you to tune in next week Tuesday at noon, as always, for another live episode of Level Up Law. And thanks again to Matt Billingsley down in our Charleston office, Kenneth Elliott, our producer back there in the background. I'm Susan Ingalls. Thank y'all for being with us. Thanks to our audience. Matt, thanks again to you. That concludes today's webinar.